Hello, I'm here on behalf of PAsentencing.com and the PAsentencing.com street team. Today I'll be informing you on the shocking truth behind parole for life sentences in the state of Pennsylvania, and I'll be presenting evidence to you that Pennsylvania's lawmakers and Pennsylvania judges do not want you to know. But before we get into that, let me first explain to you a few current events so we can all remain on the same page. As many of you may already know, the United States Supreme Court ruled on June 24, 2012, that it is a violation of the U.S. Constitution's 8th Amendment to sentence a juvenile offender to a mandatory term of life imprisonment without parole for a murder conviction. For those of you who are not familiar with this recent ruling, the federal case I'm referring to is known as Miller v. Alabama. After the ruling in Miller v. Alabama, every state's lawmakers face the responsibility of bringing their sentencing laws into conformity with the Supreme Court's decision. Act number 204, which many of you know, was introduced as Senate Bill 850 in 2012. This act was Pennsylvania's response to the Miller v. Alabama ruling, and it was signed into law by Governor Tom Corbett on October 25, 2012. This act was supposed to provide parole eligibility for all juvenile offenders sentenced to a minimum term of years for a murder conviction after June 24, 2012. However, this act does not provide any such parole eligibility. All this act does is change the way Pennsylvania judges pronounce sentences upon juveniles offenders in court. Act number 204 was not an adequate response to the Miller v. Alabama decision. This is the Parole Act of August 2011-2009, and it is 151 pages in length. This Parole Act officially repealed the previous Parole Act of 1941, and this act is the law that currently governs parole in the state of Pennsylvania. The reason why I mentioned the Parole Act of 2009 is because within that act, there is a statute codified at Section 6137 of Title 61 of the Pennsylvania Consolidated Statutes. That particular statute is titled Parole Power. And within that statute, a subsection A1, it clearly states that the Pennsylvania Parole Board cannot parole any inmate sentenced to serve a life imprisonment. So, in other words, Section 6137 of the Parole Act of 2009 is the law that prevents the Pennsylvania Parole Board from paroling any inmate serving a life imprisonment sentence, and this pertains to both juvenile and adult offenders in the state of Pennsylvania. The only way the Pennsylvania Parole Board can ever exercise lawful jurisdiction over life imprisonment sentences is if Pennsylvania lawmakers amend the restriction at Section 6137A1 of the Parole Act of 2009. However, Senate Bill 850 never amended this statutory restriction. What Pennsylvania lawmakers will tell you is that Senate Bill 850 creates a statute called Section 1102.1, which provides Pennsylvania judges with the authority to impose a minimum term of years within the overall sentence. They will mention this because that minimum term of years is supposed to guarantee that the juvenile offender has parole eligibility once the minimum term expires. However, what Pennsylvania's lawmakers won't tell you is that Section 1102.1 also forces Pennsylvania judges to impose a term of life imprisonment for the maximum term of the overall sentence. The lawmakers won't mention this because when a sentence has a minimum term of years and a maximum term of life imprisonment, the maximum term of life imprisonment is the actual sentence. The minimum term is such a sentence is merely referred to as an administrative notice to the parole board, and this fact has already been established in numerous cases under the Pennsylvania Supreme Court. But the question remains, if the maximum term of life imprisonment is the actual sentence, and the Pennsylvania Parole Board has no lawful jurisdiction over terms of life imprisonment, then how can the offender apply for parole after the minimum term expires? The answer to that question is he can't. Unfortunately, since the misleading Senate Bill 850 only applies to juvenile offenders convicted after June 24, 2012, the mistakes of this legislation won't reveal themselves until 2032, when the first juvenile offenders will attempt to seek parole under this erroneous act. There are many other statutory provisions within the Parole Act of 2009 that also prevent a person convicted of murder from having parole eligibility in Pennsylvania, such as the eligible offender definition, the technical violator provisions, and many other provisions that must be amended. As a result, PAsentencing.com has drafted a legislative bill that corrects all mistakes within the Pennsylvania parole laws and life sentencing laws. This 24-page document is a legislative bill that PAsentencing.com plans to have presented to the Pennsylvania General Assembly to be voted on in the near future. As of today, August 31st, 2013, PAsentencing.com has accumulated nearly 10,000 written and online signatures in support of our bill seeking parole for all life sentences in Pennsylvania. To support this drafted bill, sign our online petition today at PAsentencing.com. And to learn more about the truth behind life sentences and the parole board in Pennsylvania, go to PAsentencing.com's homepage and click on What is a Life Sentence in Pennsylvania option, or click on the Pennsylvania Parole Violations Exposed option. That concludes this month's video segment. Feel free to replay this video and research the facts that have been mentioned. Until next time, seek truth, be aware, and make a difference.